In this video, we're going to talk about understanding bail in Indiana. So what to do if you've been arrested and you need to figure out how to make bail, reduce bail, or post bail. About me, my name's Nathan Vining. I am a criminal defense attorney here in Indiana, and I'm here to answer some questions for you. First, what is bail? Bail is an amount of money that you post that essentially assures your appearance in court at later dates. It allows you to remain out on the street while your case is pending, and it's essentially the presumption of innocence. You post the bail, it allows you to go and build your case and work with your attorney instead of being in custody while the case is pending. Typically, there's bond schedules in every county. For a misdemeanor, it really depends on the county and the schedule, as well as your criminal history. And then for felonies, it could be anywhere from $1,000 up to $10,000, $20,000, $30,000. So there are different types of bail in Indiana. There's cash bail, which is where you just post some cash. There's a surety bond, which is where you would get a bondsman who would post a bail, and there typically would be 10% of the amount that you would post. So if it's a $100,000 bond, you would post $10,000, or a $10,000 bond, you would post $1,000. Sometimes the court will allow you to do a PR bond, which is essentially allowing a family member to post a percentage just like a bondsman. But there's all sorts of different types of bail in Indiana. And if you have a bail that you can't make, you're going to want to talk to an attorney about what kind of bond you could post and maybe get it changed. Sometimes if it's a surety bond, you can get them to switch it to a cash bond or vice versa. So when setting bail, the court looks to a lot of different things. They look at your criminal history. If you have a criminal history, a lot of times your bail would be higher. If you have a history of missing court dates or flight risk, that could also impact it. They also look at what the crime is. If it's a more severe crime, you could face a harsher bail, as well as they look at your ties to the community. So are you employed? Do you have children? Are you in the area? Or are you from out of state? So these are all the different factors the courts look to. They also look to those factors when going to reduce bail. So if you can request a bail reduction if you are in custody and can't make bail, you would file a motion to reduce bail. You would prepare evidence around your ties to the community, why you wouldn't be a flight risk. Are there conditions you could agree to that could satisfy the state and the judge? And you would present that case to the court and try and convince the judge why bail should be lowered. And if you can't post bail, you would want to talk to an attorney. Try to file that bond reduction. You could talk to a bondsman, see if you can work out a surety bond with the state. Or unfortunately, sometimes you have to remain in custody while the case is pending. If you ultimately post bail and you miss court, there is risk of skipping bail. The court can put out a warrant for your failure to appear. They could also revoke bail, so then you have to sit it out through the case. And it could also lead to additional charges such as fleeing. So ultimately, if you are dealing with bail issues, an attorney can help. We can work to reduce bail. We can negotiate different bail amounts. We could try and change it from a surety bond to a cash bond or vice versa. So if you have questions, give me a call. Again, my name is Nathan Vining. I'm a criminal defense attorney. If you are in a criminal case, definitely stay informed of your court dates, follow your bail conditions, and keep an open contact with your attorney. Here's my number. Feel free to call or text. I'd be happy to answer any questions you have.